aha yɛ nimdeɛ news sɛdeɛ da bia yɛteɛ no hanom kɔfare baa nsɛm a ɛsisie wɔ Ghana ha fa amanyɔsɛm wɔ ne amamu ho ɛne yɛde ba sɛ fa NDC MPP and other entertainment ho ɛna yɛde ba ɛma wɔn nso waso ɛteɛ mu akɔ aba bio hwɛ sɛ ɔbɛ subscribe to yɛn channel no na wɔn nsa bɛka all other relevant news a ɛwɔ ɔman Ghana mu ha ɛto wɔ bɛwie yɛ nsɛm pii ɛna ɛsisie ɛne ateate wɔn a yɛkyerɛ wɔn a yɛboro wɔn a yɛgya wɔn ntɔkwa ahodoɔ a ɛkɔ so ɔman Ghana mu asomdwe ne ateefoɔ ani abobo a ɛkɔ so na nsɛm foforɔ asɛ sisi deda ne da nyinaa na mɛka kyerɛ wɔn no aha deɛ wɔde ana wɔde asɛm firi sɛ paneɛ potɔ fam a yɛte na sɛdeɛ mpanimfoɔ nso akasa ka kom yɛ nnipakuo no mu na mɛpɛ sɛ wobɛtie saa nsɛm yi na nso wakyerɛ before that no subscribe na bio no for comment nso to aseɛ deɛ wie yɛbɔbɔ ho ne yɛhwɛ baabi asusu a ɛde bɔde ho bɛfa mpanimfoɔ se ka kom yɛ nnipakuo no mu yɛkɔtie nsɛm yi a ɛwɔ Ghana man nsɛm yi mmra ne ɛba a yɛde yɛadwenkyerɛ nso so aba tie ne yie fɛ mu aba ma abomfu wei ɛnyɛ ntɔkwasɛm yɛntie mmerɛ sisi a
Down for the details of our stories now, and we are going straight to the big one having to do with suspended Chief Justice Gertrude Torkunor. Now, she has launched a scathing attack on the Presidential Committee, probing her removal, accusing it of subjecting her to mental torture, degrading treatment, and systematic violation of her constitutional rights. In a fiery supplementary affidavit filed at the Supreme Court, the Chief Justice, which was done on the 26th of May, she painted a grim picture of an inquiry she claims is designed to humiliate her and force her out of office unjustly. Justice Torkunor's affidavit contains specific details and a litany of grievances, including one, the denial of basic rights. Now, she and her lawyers say that they were barred from using their phones or laptops during the hearing, while petitioners' counsel retained full access, a move she calls deliberate discrimination. Invasion of search. She also indicated that she underwent body searches and was denied family support, with her husband and children refused entry to the hearing room. She had complaints about the venue of the hearing, which is the Osu Castle. Now, she says hearings were held at the Osu Castle, a high security zone, unlike past Article 146 proceedings, which were conducted at the Court of Appeal, at the Courts Complex. She questions the intimidating choice of location and also raised the issue of procedural irregularities, and says petitioners were allowed to avoid testifying in person, relying instead on witnesses, a departure from standard inquiry rules requiring cross-examination under oath. So those are the key issues raised by the suspended Chief Justice, Her Ladyship Gertrude Isaba Torkunor. Now, the Attorney General also says, in a response to what Madam Chief Justice has been saying, the Attorney General has responded and says, in-camera hearing is a constitutional command geared at safeguarding not only the Chief Justice, but the entire judiciary. It can therefore not be waived. This comes on the back of the Chief Justice asking that her hearing should be made public and not in camera, but the Attorney General thinks otherwise and has responded accordingly. Also, the Attorney General says there is no basis in law for the two Supreme Court judges to be restrained from participating in the petition probe. And specifically on Justice Samuel Adibu Asiedu, the Attorney General says he did not participate in the injunction hearing and can therefore not be precluded. On Justice Gabriel Scott Poamang, the Attorney General argues his participation in cases but before the court by one of the petitioners cannot constitute evidence of bias. The AG further states that members of the committee have taken the necessary oath of office contrary to claims by the suspended Chief Justice. Now, the Attorney General concludes that a case of injunction has not been made out, and that the responses that the Office of the Attorney General has given to the concerns raised by the Chief Justice herself, who, has in the last few days been quite active in trying to, save what is left of her image following recent developments about her suspension as Chief Justice. Let's engage the thoughts and get some legal understanding on this. Martin Kpebu is a private legal practitioner. Mr. Kpebu, good evening. Thank you for joining us.
Yeah, good evening. Good.
Right, to start with, the Chief Justice in her affidavit is alleging violation of her rights and makes reference to body searches and not being allowed access to her phones and other gadgets. She also talks about the venue being intimidating. Are these justified grounds for complaint, and are her rights being violated, you believe?
Okay, this is Marina, right?
This is Martin.
Hey, boy, it looks like name. I can't recognize your voice anymore. All right. Okay, so Martin, what I see is that we can't give an objective answer to these allegations yet. What I just discussed, the reason is that these allegations the Chief Justice has made, I don't think that's what the Attorney General responded to. Yes. So you see that from what I see, what the Attorney General filed was filed on 26th. That's yesterday. Okay. And I see 3 something p.m. Yeah. That the Chief Justice owned to, I see about the same time. It's quite close. And also on the 26th. So what happens in practice is that it is not possible for the Chief Justice to file and the Attorney General to immediately respond the way they are close to each other. I wouldn't even be surprised that if I were to look at the time again, I may find that the Attorney General filed earlier than the Chief Justice. So the short answer is that the Attorney General is yet to respond to those allegations. The Attorney General is yet to respond. So when the Attorney General responds, that one will also be called a supplementary affidavit. But maybe, if you like, let me even take the phone from my ear and then double check. You see that the Attorney General's response. Okay, if you have yours there, you can look at the top. Okay. You see that the Attorney General's one is an affidavit in opposition. It's affidavit in opposition. Okay? So that's the first response to what the Chief Justice filed. But that's the earlier thing that the Chief Justice filed on 21st of May, right? But when you go to the Chief Justice one, you see that it says supplementary affidavit. Supplementary affidavit. That means it's an additional one to what she filed earlier. Okay. So the Attorney General is here to respond to what she has just filed. So let's hold our horses. Our law requires that we don't give answers when we don't have all the facts. Yes, she's made all these allegations. Yes, well, for now, it appears she has a right to complain, right? So let's hold our horses. It will be out of place for anybody to start condemning her when we haven't seen the responses of the Attorney General. Okay. That's what I would say. I'll strongly urge that we don't condemn anything until we've seen the responses of the Attorney General.
All right. So maybe based on what we know of her supplementary affidavit, where she talks about not being allowed access to her gadgets and stuff, just the specifics she has mentioned about the fact that she had to be searched before entrance. Her gadgets have been withheld from her, whilst those that or her accusers or lawyers of her accusers had access to theirs, and that they didn't allow her family members in the hearing room. These, according to her, are frustrating and intimidating her. On the face of it, while we even await the responses of the Attorney General, are these grounds on which you believe she should be the issue should be reconsidered, maybe change of venue, for instance?
Good. So, yes, like I said earlier on, this is the first time that we are getting a lot more insight as to how this particular committee is working. I think we are getting more insights into this particular committee's work than we got during the Charlotte Say one. So it appears that, like I'm saying, it's early days. Yes, I don't want to run ahead of myself. NTV3 and 3FM, we are noted for objectivity. So if we run ahead of ourselves and I say something that the Attorney General's response would subsequently show that the opinion I've given is not right, we would suffer a public backlash. So we'll wait. Yes, we're not jumping, but by way of education, I'm not saying Ghana we should copy, but I'm just showing you how sometimes the rules are changed depending on what is at stake.
Right.
But what I'm about to say, I'm not saying Ghana should copy it at all. Look, in the UK, there is this system when it comes to issues bordering on national security. They have this court system where, the accused, right? Let me call the person the accused. One, is not allowed to enter the premises where his case is being determined. The accused won't enter. He doesn't get to see what is going on in there. Rather, there's a special lawyer where he's told that tell the lawyer everything you know. So the lawyer is giving access to the charges, the information, then he relays to the accused. The accused doesn't get, and when I use accused and they are home, they will say defendant. But the key thing I'm saying is that person who stands charged, that person who suffers, who stands to suffer the consequence, he doesn't enter that room, depending on what is at stake as national security. English lawyers are complaining, but the last time I knew, they've not yet scrapped it. So what I'm just saying is that sometimes some of these restrictions may happen. I'm not talking about the Chief Justice matter, this part, that's not one, but I'm just giving education.
Right.
So that's why I'm saying let's wait a bit. But in the UK, where they have been practicing law for centuries, they are centuries ahead of us when it comes to a modern criminal justice system. This system still prevails there. I'm not saying Ghana we should copy. We will not even allow such a thing here. But I'm just telling you that sometimes there are some exigencies that may cause certain conditions to be made. And let me even further add, apart from the person who stands accused not getting the opportunity to enter that room and to see the people who are accusing him, blah, blah, blah. If that person has Martin Esiedudate as his lawyer, and Martin Esiedudate doesn't have national security clearance, that's among the lawyers in the UK, there are certain lawyers who have national security clearance. So if Martin Esiedudate doesn't have national security clearance, then he has to also go and look for another lawyer, maybe Okansi, who has national security clearance, for Okansi to now do the case. So it means that accused is forced to have two lawyers. And obviously that will involve more fees because you already had your lawyer you are comfortable with. But they say, no, this lawyer doesn't have national security clearance. He will not enter that courtroom. And so you go and find another lawyer who has a clearance, and he enters, right? So I'm giving education. So let's be patient.
Okay.
When the Attorney General responds, then we'll see.
All right, Counsel, thank you so much for this education and clarity you bring to the issue. Grateful for your time.